going. So maybe every month you require 25, 30, 35,000, 40,000 for the purpose of household expenditure. Let's say in all in the year at the rate of rupees 30,000 a month, 3.5 lakh of rupees. Plus you have deposited in the bank during the whole year a further sum of rupees 25 lakh. So 3.5 lakh which you have spent for the family, 25 lakh which you have then deposited in the bank, 28.5 lakh of rupees, your income becomes 14 lakh and 40,000. So you don't then need to maintain any books of account, and you can straight away say my income is 50% of my receipts. What is the advantage? Advantage is because you are not required to maintain books of account, you are not required to prove what is the expenditure that you have incurred. Otherwise, if I am maintaining books of account, I will have to record every income, I have to record every expenditure, I have to keep proof of expenditure, I have to keep vouchers, I have to keep all bills, I have to keep proof of every expenditure that I am claiming. If you have this particular, what they call is presumptive taxation, the law presumes half of your income is your expenditure, half of your receipt is expenditure, half of receipt is your income. This is not available if your receipts are in excess of rupees 50 lakh. Again, this is at the option of the SSC. So if I say my receipts are rupees 15 lakh, but my expenditure is in excess of rupees 7.5 lakh, because I pay rent, I have depreciation of the car, I have high expenses of, let's say, salary or whatever, it's open to me then to say I will maintain books of account and I will claim and prove that my expenses are in excess of 50%, and in that situation I will be entitled to say against my receipt of 15 lakh, I have expense of rupees 12 lakh, my income is 3 lakh. But then it is for me to prove that my income is less than 50% of receipt. If I do not want to get into that difficulty, I can straight away say, this is my receipt, half is my income, and I am paying tax on it. If I don't want to do that, if I want to prove for myself my income is less than 50% of receipt, I can still do that. For the purpose of planning, what should be done? I would say, ordinarily my call is, your income would be more than 50% of receipt, except you end up spending lot of amount like depreciation of motor car or some such thing. Normally, I don't believe that the cost of earning professional fee would be in excess of 50% of your total receipts. So in a way, this is good for you. You just deposit the amount in the bank, whatever you have, on the basis of what is it that is deposited in the bank, and on the basis of what you have spent without depositing in the bank, take half of it, pay tax, and be done with it. Except you are really particular about proving your expenditure when it happens to be more than 50% of your total receipts. So this is one provision introduced only from this year, which to a certain extent would be to the advantage of the SSCs. Having said this, what are the ways in which lawyers can probably end up saving some kind of tax? Now, it is not as if for lawyers there is a special set of rules which would entitle them to save taxes as compared to other professionals. Lawyers are also bound by the same set of rules with which other professionals are concerned. But then, if you, for example, if you are taking office on the rent, which you are required to take, if it is possible, you can take rent from family member and pay rent. It's not necessary that the person from whom you have taken premises on rent has to be an outsider. It can be your father or even your wife, spouse. And if you pay rent, so long as the rate at which the landlord is being taxed is lower than your rate of tax, you still end up saving something. Let's say father is retired and is only having the pension income or interest income, does not have any taxable income, by charging rent in your books of account, you can shift the income to the father's account and thereby see to it that the amount that you pay would be deductible in your hand, in the hand of the recipient. It does not get taxed at the same rate. Similarly, it is not legally impermissible to give salary to near relatives, including spouse. I am saying it is not legally impermissible, meaning thereby it is legally permissible provided you can justify it. If the spouse is already working elsewhere on a full-time basis, you cannot say that I am also employing the spouse for the purpose of carrying out my office work. But if the spouse is not employed elsewhere on a full-time basis, and if you can justify the salary, pay the amount of salary to him or her, and you will be getting amount as a deduction. So you can also get deduction by incurring expenditure, but at the same time ensuring that expenditure which is paid by you remains within the family. At times people also take the shelter of depreciation, especially by buying vehicles. You buy a car, depreciation that you will get on the vehicle at 15% of the cost of vehicle would be allowed as a set-off against your professional income. I am not necessarily advocating it for all purposes, because when you buy a car, especially fancy car, it's an expensive proposition. So you also end up paying interest on the vehicle loan which you might have borrowed for this purpose. So this may not be taken to be a tax planning device, but if you need to buy a car, which you normally one would require to buy the car, you can think in that particular direction to ensure that it is not as if that cost of buying the car would go west and you will not be entitled to claim depreciation. So effectively you earn money, you spend on the expenditure which you have incurred for the purpose of earning money, net becomes your income. It is this income that you are liable to pay tax on. Having said this, in relation to lawyers, let me now go to 4 or 5 other provisions which are being used for the purpose of planning. They are not exclusively in relation to lawyers. Nonetheless, they are all very, very useful sections which will entitle you to reduce the tax liability. One, and the most popular, is the investments into eligible kind of investments under section 80C. If you invest up to rupees 1.5 lakh towards either insurance premia or towards public provident fund or towards payment for construction of a residential house or towards educational expense of 2 children, including tuition fees or the cost of fees for university, college, school or any other recognized course, collectively up to rupees 1.5 lakh, you will get deduction. These are all to encourage SSEs to save, to invest, and to ensure that at a future date, the money comes to the SSE as and by way of when in future you need money. Unlike employees who have provident fund and therefore from their salary the amount gets deducted every month, which piles up into the provident fund contribution of employee with a matching contribution from employer, resulting into a reasonably good sum when the employee retires. So far as professionals are concerned, there is no such fund available when you ultimately give up practice, retire from the practice voluntarily or on account of ill health. There is no one to help you. There is no provident fund. It is for this reason the law envisages that you may contribute into a fund known as public provident fund, and if you spend up to rupees 1.5 lakh into public provident fund, the amount that you pay would be allowed to you as a deduction from your income. In other words, if your, let's say, professional fees are rupees 20 lakh, on hypothetical basis, 50% is my income, so my income is rupees 10 lakh. If I invest rupees 1.5 lakh, my income will further go down from rupees 10 lakh to rupees 8.5 lakh. So the amount that you must invest in public provident fund or in insurance premium, I would take a view, everyone must take advantage of this, because it is very much necessary considering high pressure of work, considering the fact that human life itself is fragile. It is necessary to keep track of the health, and also to see that in future if something happens to anyone, the family members have some funds on which they can rely. You must start keeping money aside, and the only way professional can keep the money aside with some tax saving is by investing into either public provident fund or towards the amount that you may pay towards insurance premium, because ultimately if it's insurance premium, you will at some point of time insurance policy may mature and you may get back your money. And therefore this is one form of investment which is certainly a tax planning tool available to the SSCs. The medical health policy, Mediclaim policies, insurance premium that you pay up to rupees 25,000 per annum would also be allowed to you as a deduction. Not only this, if there are aged parents of more than 80-year-old, if you incur up to rupees 30,000 per annum expenditure for their medical treatment, even their medical treatment expenditure is also now being allowed as a deduction from the income that you would earn. The government is keen to ensure that people spend money for the purpose of higher education. So if you have borrowed loan for the purpose of higher education, interest that you pay on the loan borrowed for the purpose of higher education would be allowed as a deduction. So not only for education of one's own self, education of one's spouse or one's children, for higher education, you want to send your child to law school and you have to borrow money for the purpose of paying high tuition fees, amount that you borrow that will carry interest that you pay is allowed to you as deduction under section 80E. So again, you may consider that if I have, let's say, from the planning point of view, I need to pay rupees 5 lakh as fees. I have 5 lakh available to me. But if I invest 5 lakh somewhere else, I'll get interest at 12%. Whereas if I borrow rupees 5 lakh from a bank, etc., towards educational loan, I may end up paying interest at 10%, 9%, 8%. I may think of doing it because interest that I pay would be allowed to me as a deduction in relation to my income. If you borrow money for the purpose of construction of house, interest that you would pay on the housing loan would also be now allowed to you as a deduction. However, from this year, this deduction is not to be in excess of rupees 50,000 per year. Secondly, the house that you may buy should not be in excess of rupees 50 lakh in value, and the loan should not be of an amount in excess of rupees 35 lakh in value. So if you borrow up to rupees 35 lakh, interest that you pay up to rupees 50,000 would be allowed to you as a deduction. If you pay rent for your house, subject to certain conditions which are technical, I am not going into the conditions. If you pay rent for the house, subject to certain conditions, you will get deduction up to rupees 5,000 per month or rupees 60,000 per annum. So if you have no residential house, one of the conditions being you should not be having a residential house. If you have no residential house and if you are paying rent, consider whether or not you would be entitled to claim deduction in relation to the rent that you have paid for residential house. For office, it will always be allowed. I am not an office. I am in fact on your residential house. So that interest that you pay on the loan borrowed for residential house is also allowed as a deductible expenditure. So effectively what happens is you find out, I now go back to the main issue. You find out your receipts. Find out whether you would like to pay tax at 50% if your receipts are below rupees 50 lakh. If yes, Don't bother to keep books of account, etc. Take 50% of your receipt, find out if you have some other income, and then find out what are the allowances, deductions which are admissible to you, and on that basis, you end up paying tax. One more aspect about that presumptive taxation to which I made a reference, 50% of a receipt is to be taken as income. It's not as if once you choose to go by that methodology, you must adopt that methodology year after year. In 1 year, I may choose to go by this presumptive tax. When I find I don't want to get into the hassles, I may say my receipts are 40 lakh of rupees, I'll pay tax on 20 lakh. Next year, let us say my receipt is rupees 35 lakhs, but I still believe that my expense is more than rupees 17.5 lakh. By maintaining books of account for year number 2, I can still claim my expenditure is more than 50% and therefore allowed to me as deduction in relation thereto. Therefore, this is the taxation of lawyers, because it's not something which is so different from other set of professionals. It is not as if I can tell you what are the special tips. What I am trying to point out to you, what is it that we should do for the purpose of A, minimizing the tax liability, and B, at the same time ensuring that you have enough money to live well with. Couple of more issues over here, and these are the issues which are required to be shared because these are problems which normally people end up not observing. One, under the Income Tax Act, there is a provision that if you spend for an expenditure in cash in excess of rupees 20,000, the expenditure will not be allowed to you. So do not spend in cash. In other words, spend only by of account pay check or account pay bank draft in excess